Democratic legislators in Virginia are advancing multiple bills they claim will decrease gun violence throughout the Commonwealth. The Virginia House has approved not one, not two, not three, but 8 separate gun control measures. The political establishment cannot resist attempting to stomp all over and violate our fundamental firearm freedoms, tackling gun control through substantial reforms advanced through committees on strictly partisan votes. Among these modifications would be a prohibition on assault weapons. They span from limitations on what firearms residents may possess to locations where Virginians can carry them, and not prohibit an entire category of firearms frequently selected by responsible citizens. One date. One solitary date hidden deep within 2 pieces of legislation. Currently moving through Virginia's legislature could permanently eliminate your opportunity to possess the most widely owned rifle in America if you reside in the Commonwealth. And here's what renders this genuinely frightening. The majority of firearm owners in Virginia remain completely unaware it's approaching. Virginia has traditionally been regarded among the most secure states nationwide for Second Amendment protections, the very birthplace of the Bill of Rights, a commonwealth where possessing firearms wasn't merely permitted, it was embedded within the cultural identity. Yet, something essential has shifted in Richmond, and the velocity at which it's occurring ought to alarm every gun owner across every state, not merely Virginia, because what is currently unfolding isn't simply a regional policy adjustment, it's an experimental model, and should it succeed here, your state might follow. For decades, Virginia firearm owners possessed protection, a governor prepared to reject restrictive laws prior to their enactment. Glenn Youngkin functioned as that barrier, preventing numerous gun control proposals throughout his tenure. However, his administration has concluded, and his successor maintains a radically different ideology. Governor Abigail Spanberger, previously a CIA operative who campaigned with substantial support from gun control groups such as Everytown for Gun Safety, has articulated her stance unmistakably. She won't be grabbing her veto instrument, certainly not regarding this matter. And that sole transformation at the leadership level has entirely liberated the Democratic majority within the General Assembly. They aren't merely proposing fresh gun legislation, they're reviving each individual bill Youngkin defeated and accelerating them through at unprecedented velocity. Years of accumulated legislative momentum is presently overwhelming the system simultaneously. Now, the focal point of this entire initiative demands thorough comprehension, because the manner in which it's drafted is deliberately constructed to encompass the broadest conceivable spectrum of firearms. We're examining House Bill 2127, alongside its Senate equivalent, SB 749. These measures establish an extensive prohibition on what state officials designate assault firearms. And, before you dismiss that terminology, allow me to clarify why the definition they're employing proves considerably more threatening than you might anticipate. Democratic legislators in Virginia are advancing multiple bills they claim will decrease gun violence throughout the Commonwealth. We might witness the ideal convergence of Second Amendment litigation, all arriving before the Supreme Court simultaneously. Concurrently, more stringent firearm regulations progressed another step toward implementation, clearing the Senate merely days ago. The legislation would block commerce in specific firearms. What they've accomplished presently is they've adjusted their assault weapons prohibition so that it affects not merely assault weapons, but magazines additionally. We endorse the legislation. We believe instruments of warfare have no business on our thoroughfares. Among the most comprehensive modifications would terminate commerce in assault weapons. Consider AR-15 platforms. They seize items millions of Americans possess lawfully, reclassify them as hazardous, then they alter the definition. Under this proposed law, a semi-automatic centerfire rifle gets categorized as an assault firearm, provided it accommodates a detachable magazine and possesses merely one supplementary characteristic. Just one, a collapsible or telescoping stock satisfies, a pistol grip satisfies. A threaded barrel capable of accepting a muzzle attachment satisfies. Reflect upon that briefly. They didn't draft this to target some rare military armament. They crafted it to ensnare your typical AR-15, your AK pattern rifle. Essentially, every contemporary semi-automatic rifle displayed at firearm retailers throughout the Commonwealth currently. However, it doesn't cease with rifles. The measure additionally captures semi-automatic shotguns featuring revolving cylinders or capable of accepting detachable magazines, meaning that home defense shotgun you assumed remained protected from such legislation. Perhaps it isn't. They even targeted magazines forbidding commerce in anything containing beyond 10 rounds provided it was fabricated following a particular cutoff date. And that cutoff date represents where this entire situation becomes genuinely catastrophic. July 1st, 2026. Here's the mechanism of the snare, and I'm labeling it a snare because that's precisely what it constitutes. Commencing on that date, the importation, sale, fabrication, acquisition and transfer of these newly classified assault firearms becomes prohibited in Virginia. Now, there exists a grandfather provision should you currently possess one of these firearms, and it was manufactured prior to July 1, 2026, you may retain it. Yet, and this constitutes the element that transforms everything. You cannot transfer it. You cannot vend it to your neighbor. You cannot present it to your hunting companion. And in most circumstances, you cannot even bequeath it to your own offspring. Democratic legislators in the General Assembly additionally pressing forward with among their most disputed gun control proposals, the prohibition on assault weapons. Two firearms can operate identically. One remains legal, one becomes illegal based purely upon appearance. Significant Second Amendment litigation sits before the Supreme Court today. Numerous additional rifle and magazine prohibition challenges are queuing for that identical conference at the Supreme Court. This isn't merely some gun rights lawyer declaring it, this is the U.S. government acknowledging it. They're stating these laws cannot withstand brewing. The exemptions prove so restricted they scarcely exist. What this signifies, in practical terms, constitutes that the state has imposed an expiration date upon these firearms, not through confiscating them presently, but through ensuring they perish alongside their current proprietors every year following 2026. There will be progressively fewer of these firearms in lawful circulation within Virginia inside a generation. They'll become functionally extinct throughout the Commonwealth, and that is entirely intentional. So, who precisely propels this? The principal architects comprise State Senator Saddam Salim and Delegate J.J. Singh. Senator Salim has been notably vocal, characterizing gun violence as an epidemic and repeatedly contending that so-called instruments of warfare don't belong upon Virginia's thoroughfares. He's encountered considerable criticism from opponents who assert his legislative priorities mirror the restrictive frameworks of foreign nations, rather than the traditions embedded within America's foundational documents. On the resistance side, Senator Mark Peake has emerged among the most prominent opponents, declaring the bill a direct infringement upon the Second Amendment and arguing that this represents precisely the governmental overreach the right to bear arms was established to prevent. Yet, let's discuss what occurs to you personally should this pass and you commit an error, because the penalties are structured in a manner that generates maximum hazard for ordinary firearm owners. A violation gets classified as a Class 1 misdemeanor in Virginia, which carries maximum 12 months incarceration and considerable monetary penalties. That alone proves severe, but the genuine destruction stems from what follows conviction. Should you be found guilty of violating the statute even once, even on a technicality, you forfeit your right to possess any firearm for 3 complete years. Not merely the prohibited ones, every single one. Every shotgun, every hunting rifle, every handgun in your safe becomes prohibited for you to handle. One technical violation of a characteristics-based prohibition, and the state strips you of your entire capacity to protect yourself and your household. This is engineered to render firearm ownership so legally dangerous that individuals simply cease participating. It transforms law-abiding citizens into criminals through complexity and bureaucratic pitfalls that prove nearly impossible to navigate flawlessly. Now, here's where matters become genuinely fascinating from a legal perspective, because superficially, this prohibition appears headed toward direct conflict with the United States Constitution. The Supreme Court's ruling in Heller and more recently in Bruen have established unambiguous principles. The government cannot prohibit firearms that remain in common utilization for legitimate purposes. There exist over 20 million AR pattern rifles in civilian possession throughout this nation. Characterizing them as unusual or dangerous from a legal standpoint constitutes an argument that simply cannot withstand examination under current Supreme Court precedent. Thus, we are advancing toward among the most significant Supreme Court moments for firearm rights in numerous years. For 10 years, there existed a prohibition on so-called assault weapons and high-capacity ammunition magazines. We must implement proper mental health evaluations, and we must establish appropriate judicial supervision. They begin comparing civilian firearms to military equipment, as though the military doesn't employ pistols. Blades civilians already possess authorization to own. The Bruen decision proceeded further, mandating the government demonstrate a historical tradition of comparable regulation from the founding era to justify contemporary restrictions, and spoiler, no historical tradition exists of prohibiting standard-bearer arms from 1791. It simply doesn't exist. Yet, here's the difficulty: the Supreme Court doesn't accept every case, and the lower tribunals that will initially handle challenges to this Virginia law haven't exactly demonstrated friendliness toward Second Amendment claims. Virginia falls within the Fourth Circuit Court of Appeals, which maintains a record of antagonism toward Second Amendment assertions. We've observed tribunals in Illinois and Maryland execute extraordinary legal contortions to sustain comparable prohibitions, even after Bruen rendered the constitutional standard abundantly transparent. The aspiration remains that the Supreme Court will eventually accept an assault weapons prohibition case directly, and numerous legal analysts believe that could materialize during the 2026 or 2027 term. Yet that schedule implies the Virginia prohibition could achieve full implementation before the highest tribunal in the land obtains opportunity to rule, and meanwhile, people's rights remain suspended. There exists additionally a cultural component to this conflict that's impossible to overlook. Should you examine where these bills' sponsors originate, you'll detect a pattern. The most vigorous support emerges from Northern Virginia, locations such as Fairfax County and Falls Church, regions densely populated with federal government workers and Beltway professionals. There exists a pronounced cultural division between these suburban districts and the rural portions of Virginia, where firearms constitute a daily component of existence, where hunting and self-sufficiency aren't political declarations, but simply how individuals live. The legislators from these northern districts aren't merely responding to their constituents' preferences. They're promoting a vision of governance where the populace gets administered by credentialed specialists and where individual armament gets viewed as an obsolete concept. This isn't simply a policy dispute. It's a fundamental clash regarding what variety of country America shall become. So, what does all this imply moving ahead? Every indication suggests these measures will arrive at the governor's desk and that she will execute them. When that occurs, the countdown officially commences toward July 1st, 2026. Between now and then, anticipate a surge in firearm acquisitions throughout Virginia as individuals scramble to obtain what they can before the opportunity seals permanently. Legal challenges will be submitted immediately, yet injunctions remain far from assured, particularly within the Fourth Circuit. The state is wagering upon the reality that most individuals lack the financial resources to wage a multi-year legal battle. They're depending upon attrition. They're depending upon exhaustion. They're depending upon the upcoming generation, maturing in a world where these firearms simply aren't accessible and therefore aren't missed. And that's the genuine strategy here. This isn't merely about Virginia. Every gun control organization nationwide is monitoring Richmond currently. They're analyzing the legislative language, the political dynamics, the judicial responses. Should this model succeed in Virginia, a state possessing profound Second Amendment roots, it becomes the blueprint for replication everywhere. State following state following state, the definitions are drafted, the deadlines are established, the penalties await. The sole remaining question becomes whether the legal system and the citizens of Virginia will permit this to remain unchallenged. Should you care about this matter, now constitutes the moment to pay attention. Not next year, not when the deadline approaches within a month, right now, because by the moment most individuals recognize what's transpired, the gates will already be shut. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.